What happened today in a federal courtroom in Manhattan was not a legal proceeding. It was not a trial strategy. It was an attempted coup d'etat against the American judicial system itself. We need to be very clear about the gravity of the images and reports flooding out of the Southern District today. We are not talking about an objection sustained or overruled. We are not talking about a heated sidebar. We are talking about the moment the legal representatives of a former president of the United States decided that the laws of this country no longer apply to them, and they attempted to physically flee the jurisdiction of a sitting federal judge while court was in session. If you are looking for business as usual, turn the channel. If you are looking for the sanitized, both sides interpretation of today's events where we pretend this is just aggressive lawyering, you are in the wrong place. What occurred today was a stress test of the Constitution, and for 7 minutes and 23 seconds, the structural integrity of our democracy held by a thread. The narrative you are hearing from the mainstream press, that this was a walkout, is dangerously insufficient. A walkout is a labor dispute. This was a mutiny. This was a calculated, choreographed insurrection inside the halls of justice, designed to shatter the authority of the courts because the facts were no longer on their side. Let's strip away the noise and perform a forensic reconstruction of this morning. To understand the explosion, we have to understand the fuse. The morning began with a deceptive calm, the kind of bureaucratic banality that usually defines federal white-collar criminal trials. There were routine arguments over the admissibility of financial documents. It was dry, it was technical, it was normal. But under the surface, a panic was brewing that would eventually tear the proceedings apart. The catalyst was a catastrophic error, or perhaps a divine intervention, depending on your perspective. For exactly 17 minutes this morning, sealed court filings were accidentally uploaded to the public PACER system before being frantically scrubbed. In the digital age, 17 minutes is an eternity. Those documents, which we have now reviewed, revealed that the prosecution had submitted new, earth-shattering evidence just 48 hours prior. We are talking about a cache of 847 pages that the defense team never expected to see the light of day. This wasn't just paperwork. This was the smoking gun. The filings detailed direct encrypted communications between Donald Trump and his co-defendants during the so-called blackout period, a specific time frame where they had sworn, under penalty of perjury, that no contact had occurred. The documents allegedly contain records of wire transfers totaling $4.7 million. Let that sink in. Nearly $5 million moving through a labyrinth of shell companies and offshore accounts, accompanied by what sources are describing as the most damaging paper trail ever assembled in a case of this magnitude. When Judge Patricia Caldwell, a Reagan appointee with 31 years of unblemished service on the bench, ruled that all 847 pages were admissible, the air didn't just leave the room, it was sucked out by the vacuum of sheer terror coming from the defense table. This is the moment the timeline fractures. This is the moment law turned into chaos. According to courtroom transcripts and the accounts of 3 separate credentialed reporters present in the gallery, lead defense attorney Robert Sterling did not object. He did not ask for a recess to review the documents. He did not file a motion for a continuance. Those are the actions of a lawyer operating within the boundaries of a civilized legal system. Instead, Sterling's face reportedly drained of color. He looked at his co-counsel, Jennifer Matthews, and then he looked at his client. What happened next was an act of performative anarchy. Sterling stood up. He began gathering his papers. This is a federal courtroom. You do not pack your bags while a judge is speaking. You do not turn your back on the bench. But Sterling, clearly operating on instructions that had nothing to do with the law and everything to do with political theater, interrupted Judge Caldwell mid-sentence. Court reporter Maria Rodriguez captured the exact words, and they should chill you to the bone. Sterling declared, "Your Honor, this court has abandoned all pretense of impartiality. We cannot and will not participate in what has become a predetermined show trial." His co-counsel, Jennifer Matthews, joined the chorus, adding, "This is prosecutorial misconduct at its worst, and we refuse to legitimize it with our presence." This language is not legal argument. It is a press release. It is a stump speech disguised as a motion. It was designed for the cameras outside, not the jurist inside. But the most terrifying moment came from the defendant himself. Donald Trump, seated at the defense table, was observed whispering to his remaining local counsel. 3 sources have confirmed his words. "Let them arrest me. It'll guarantee the nomination." There it is, the quiet part said out loud. The calculation that martyrdom is more valuable than innocence. The belief that a mugshot is a campaign asset and a jail cell is a podium. This was not a legal defense. It was a campaign rally held at the expense of the rule of law. But Judge Patricia Caldwell is not a prop in a reality television show. She is an Article III judge, vested with the judicial power of the United States, and her response was swift, historic, and devastating. She did not bang her gavel. She did not raise her voice. She did something far more terrifying. She called for the United States Marshals. In a scene that has not played out in a federal courthouse in over 20 years, Judge Caldwell ordered the doors sealed. "Counselors," she said, her voice cutting through the murmurs of the gallery, "if you take one more step toward that door, I will hold you in criminal contempt and issue bench warrants for your immediate arrest." Let's pause and analyze the weight of that threat. Criminal contempt is not a fine. It is not a slap on the wrist. It is immediate custody. It is handcuffs. It is a holding cell. Judge Caldwell was threatening to arrest 3 of the highest-paid, most high-profile defense attorneys in America right there, on the spot, for abandoning their client and sabotaging a federal trial. She turned to the prosecution and said, "I will not tolerate theatrical departures designed to prejudice potential jurors. This is a court of law, not a reality show." And then, the standoff. For 7 minutes and 23 seconds, time stopped. 6 U.S. Marshals, armed and armored, positioned themselves in front of the double mahogany doors. They physically blocked the exit. Think about the visual. On one side, the agents of federal authority, sworn to uphold the orders of the court. On the other, the agents of chaos, freezing in their tracks, caught between their political instructions and their personal liberty. Spectators reported you could hear a pin drop. The tension was palpable, a physical weight in the room. Bloomberg's senior legal correspondent tweeted from the gallery that she had never witnessed a confrontation of this intensity. Sterling's hands were reportedly shaking. He was looking at the marshals, then back at the judge, then down at his phone. And here is a detail that cannot be overlooked. As Sterling stood there, frozen, weighing whether to become a martyr or a lawyer, his phone lit up on the counsel table. The contact name displayed was Rudy. He didn't answer it, but he glanced at it repeatedly. The symbolism is too perfect. The ghost of past legal failures calling out to the present disaster. Meanwhile, Trump sat there, watching the chaos he had engineered, with a slight smile. He was taking it in. To him, this wasn't a failure of his legal team. It was the success of his brand. Chaos is the currency, and business was booming. The standoff ended only when the reality of incarceration outweighed the value of the stunt. Sterling and his team returned to the counsel table, but the damage was done. The judge's subsequent statement was the legal equivalent of a nuclear strike. Given counsel's attempted abandonment of their client mid-trial, she announced, "I am considering appointing shadow counsel to ensure the defendant's Sixth Amendment rights are protected." Shadow counsel. This is the break glass in case of emergency option. It means the judge does not trust these lawyers to do their jobs. It means the court is preparing to bring in backup attorneys, unaffiliated court-appointed professionals, to sit in the room and take over instantly if the defense tries this stunt again. It is a humiliation. It is a declaration that the court views the defense team not as officers of the court, but as saboteurs. The financial implications alone are staggering. Sterling's firm has billed over $12 million in legal fees. Now they face potential sanctions that could reach 7 figures. But money is replaceable. A law license is not. The New York State Bar Association has already signaled that unilaterally withdrawing from a case mid-trial without judicial permission is grounds for disbarment. Legal ethics professors are calling this career suicide. But why do it? Why risk your license, your reputation, and your freedom? Because they are terrified, and they should be. The behavior of the defense team, the panic, the flight response, the coordination, only makes sense when you look at what they were running from. It wasn't just the 847 pages of wire transfers. It was something else, something the judge revealed only after order had been forcefully restored. Judge Caldwell announced she had received a sealed ex parte submission from the Department of Justice that very morning. For those who don't speak legalese, ex parte means one-sided. The prosecution told the judge something the defense didn't know, and the judge ruled that based on this information, she was considering sequestering the jury and enhancing security. Legal experts know what this means. You don't sequester a jury for wire transfers. You sequester a jury when there is a credible threat of tampering or violence. You enhance security when the stakes have escalated beyond white-collar crime into the realm of organized criminal enterprise. The implication is screamingly loud. The prosecution has a witness on the inside, a witness whose testimony is so devastating, so specific, and so dangerous to the defendant that the government had to keep their identity secret until the last possible second. We are looking at a classic mob trial dynamic. The walls are closing in. The circle of trust has collapsed. Someone has flipped. And when the defense team realized that the blackout period was no longer blacked out, that the encrypted messages were decrypted, and that a human being was prepared to take the stand and walk the jury through the crimes, they pulled the ripcord. They tried to blow up the trial because they knew they couldn't win it. They tried to manufacture a mistrial through chaos because they couldn't secure an acquittal through facts. This is the strategy of the desperate. It is the strategy of the guilty. And this brings us to the most chilling realization of the day. This wasn't an isolated incident. It was a test run. If Trump's lawyers had successfully walked out of that courtroom, if they had defied a federal judge and walked past those marshals without consequences, the precedent would have been set. It would have signaled to every defendant with a bank account and a political following that the justice system is optional, that you can opt out of your own trial if you don't like the way it's going. Judge Caldwell held the line today. She physically barred the exits and forced the process to continue. But we are now in uncharted territory. We have a defendant who openly challenges the legitimacy of the court, a defense team that views disbarment as a badge of honor, and a political movement that is cheering on the destruction of the judiciary. The events of this morning were not just a legal crisis. They were a warning. The system is blinking red. The guardrails are smoking. And as we look toward what comes next, the testimony of the mysterious Witness 14, the impending sanctions, and the inevitable appeal, we have to ask ourselves, how much more strain can this system take before it snaps? The courtroom is supposed to be a sanctuary of truth. Today, it was a battleground. And while the Marshals won this round, the war on the rule of law is escalating. The defense has shown their hand. They have no intention of fighting this on the merits. Their only play is to burn the courthouse down and rule over the ashes. We are watching a slow-motion collision between a man who believes he is the law and a system designed to prove that no man is above it. Today, the system pushed back. But the desperation we saw in Sterling's eyes, the frantic coordination, the abort mission text messages that we will discuss in a moment, it all points to one undeniable fact. They know something is coming, something they can't spin, something they can't tweet away, and something they can't walk out on. This is the autopsy of a judicial insurrection. The body is still warm, and the perpetrators are still at the table. But make no mistake, the attempt to murder the fair administration of justice happened in plain sight, on the record, and under the seal of the United States District Court. And if you think today was explosive, you have no idea what is waiting in the wings. Let us perform a forensic timeline analysis on the precise moment the system began to fracture. At exactly 11:42 a.m., Robert Sterling's phone lit up with two critical words: abort mission. 5 minutes later, the defense table was abandoned. This was not a spontaneous legal objection. This was a remote-controlled demolition of judicial order. When a political operative outside the building has the power to command officers of the court to violate their sworn oaths inside the building, we have crossed a terrifying threshold. We have ceased to function as a republic of laws and have devolved into a theater of the absurd. This is the authoritarian endgame in its purest form. If you cannot win the game on the merits, you flip the board and set fire to the pieces. The image of 6 U.S. Marshals physically barring the exits of a federal courtroom, standing shoulder to shoulder like a Praetorian guard protecting the concept of justice itself, is the defining visual of this crisis. It represents a system pushed to its absolute tensile limit. Judge Caldwell was not merely maintaining order, she was physically holding the line against anarchy. When she threatened to remand these high-profile attorneys to custody, she was acknowledging a dark new reality. The traditional incentives of the legal profession, reputation, licensure, decorum, no longer apply to agents of chaos who are fighting for a post-legal future. The guardrails aren't just smoking, they are melting under the heat of this assault. This is what happens when the legal system meets a force that refuses to recognize its authority. We must understand the architecture of this insurrection. The defense is gambling on the belief that the American judicial system is too polite, too slow, and too paralyzed by its own traditions to withstand a frontal assault. They are weaponizing due process against itself. Every frantic motion for a mistrial, every theatrical departure, and every coordinated media leak is a calculated strike designed to delegitimize the outcome before the verdict is even read. They want the public to look at those locked doors and see tyranny, rather than seeing the necessary containment of a rogue faction. They are betting that if they generate enough chaos, the Constitution will simply fold under the weight of the noise. But panic is a clumsy architect. The sheer desperation we witness today reveals the true stakes. Why risk immediate disbarment? Why risk jail time for criminal contempt? The answer lies buried in that sealed ex parte submission regarding Witness 14. The defense's calculation is brutal but transparent. It is better to detonate the trial now than to allow that specific testimony to enter the public record next Tuesday. They know that once Witness 14 speaks, the carefully curated narrative of a political witch hunt evaporates, replaced by the cold, hard arithmetic of financial crimes. The system is blinking red because the pressure is rising from the inside out. They are desperately trying to breach the hull before the truth sinks the ship. As we stare down the barrel of next week's testimony, one thing is inescapable. The collision between the rule of law and the will to power is no longer theoretical. It is here, it is violent, and the final impact is imminent.